Well, so the product of the day is carrier's legal liability. Carrier's legal liability. This is one product which we have launched some 2-3 years back only. But now this has been popularized like anything. Reason being, this is the most required policy and this is not a new product. Companies are already having it. And PSUs were having since beginning. Because as far as the carriers or transporters community is concerned, they are solely dependent upon this policy only. Why this is required? What is this policy? What is the purpose? Who needs this cover? What would be the coverage? All these things are important to understand before we sell this policy. Because whenever we are sending any goods, any cargo, any shipment, any consignment, we think twice, thrice or 4 times that how we should send it, by what mode we should send it. Because plenty of ways are open before us. If we are choosing waterways, there we have to consider port-to-port facilities. If it is there, then we can send it by ship, steamer, boats or any kind of one. If we are selecting the airways, in that case the goods or cargo will go by the air cargo carrier, helicopters or by any air device. If we have determined to send by railways, in that case there are some goods trains or any other specific train which is specially designed to send the goods or bulky cargoes. But the most popular one is roadways. Because whatever is the distance, maybe the small or the long, it can be covered by the roadways vehicles. And when we are using the roadways, the goods is transported through the GCCB. Now this GCCB is a very popular term in motor insurance because all the goods carrying commercial vehicles are insured under the GCCB policy. So this goods carrying commercial vehicle may have variety of vehicles. So for example, light commercial vehicle, medium commercial vehicle, heavy commercial vehicle. And again, there could be different designs like tankers, refrigerated vehicle, open body, closed body. So all these kind of vehicles are being used for the goods carrying or goods transporting purposes. When we talk of the carrier's legal liability insurance, our carrier's legal liability insurance is related only to the roadways, neither waterways, nor airways, nor railways. Means the vehicles carrying the goods through the road route are subject of the carrier's legal liability insurance policy. So why carrier's legal liability insurance is required for such vehicles? Because whenever there is the movements of goods or merchandise or cargo from one place to another place, there is a risk of being damaged during the transportation, during the loading and unloading of business, during the stay of the vehicle, loaded vehicle. So these risks are attaches from the point of origin to the point of destination. Now if the goods are damaged in transit, the owner of the goods or marine insurer, in case of subrogation under marine policy, if any, may sue the transporter for the losses. That means if somebody is sending his goods through the transporter, but he has taken an insurance policy from the insurance company and after insuring it, sending through the transporter. Still, if the goods is damaged in the transit, if the goods is lost in the transit, possibility is there. Because if the vehicle is accidented, vehicle is fallen in a river, vehicle is burned, the goods will also get damaged and is lost totally. So in such a case, either there is an insurance or there is no insurance. The possibility of loss or damage to the goods is always there. If the insurance is there, the owner of the goods will always try to take insurance or the compensation or the claim from the insurance company. Because he has paid for it, he has got the insurance policy, so he will always prefer to claim his loss or damages from the insurance company. This is so simple. But in case he has no insurance, and still the goods is lost or damaged, then the only option left is that he will recover the amount of the loss or damage from the transporter. But here again the question is, suppose the insurance is there and the owner of the goods has claimed the loss from the insurance company. So the insurance company will ask for a subrogation letter from him because the company has already indemnified the losses. Now this is the duty of the insured to give the subrogation letter to the insurance company. This subrogation letter is the transfer of rights and remedies to the insurance company. Once the insurance company gets the subrogation letter from the insured, they will exercise this option against the transporter to recover the losses paid by them to the owner. Means whatever amount is paid by the insurance company to the owner of goods for the loss or damages, insurance company will recover that amount from the transporter who is responsible for the loss or damage on the basis of the subrogation letter. That means either the insurance is there or no insurance is there. Under both the circumstances, it is the duty of the transporter to pay for the loss or damages. Either they have to pay to the insurance company or to the owner of the goods. But the transporter cannot escape the liability. Carrier or logistic firm cannot escape the liability. Ultimately, they are liable for the loss or damage to the goods which they are transporting because they are charged the freight for that. So it is their duty to safely deliver the goods or cargo from one place to another place wherever the goods is to be directed to place or to deliver. So this is one big liability transporter firm is carrying. This is one big liability every transporter, carrier or logistic firm has to bear because the loss or damage in transportation is a routine affair. It can be an everyday affair. It all depends upon the carrier or transportation firm, how many vehicles they are carrying and how many vehicles are being used on everyday basis for transporting the goods. If they are transporting the goods in 20 vehicles or 30 vehicles or 50 vehicles every day, there is a possibility that loss or damage can be there to the goods in 1 vehicle, 2 vehicle, 5 vehicle, 10 vehicles. Nobody can rule out the possibility. So when this is likely that every day there could be the possibility of the loss of damages, how much money the transporter will pay to the owners of the goods in case of losses or damages caused by the accidental reasons? Maybe by the accident, maybe by the fire, maybe by the explosion, maybe by the falling of the vehicle, maybe by the negligence. So how much amount of compensation the transporter will pay? So in such a case, carrier's legal liability policy comes to the rescue of the transporter or the carrier or the logistic firms to cover such liabilities. Now, these are the three kind of businesses who can take this policy. transporters, carriers and logistic firms. Because their job is to transport the goods from one place to another place. They are working as carriers of goods or cargo. Vehicles can be owned or hired by them. This is again an important question. Because this is not necessary that every transporter or carrier firm is using their own vehicles only for transporting the goods. This is not always possible. The transport firm may use their own vehicles as well as the hired vehicle for transportation of goods. It all depends upon their turnover, how much turnover they are having. If their turnover requires more vehicles, they can hire, or if they are capable, they can purchase more vehicles. But the carrier's legal liability insurance policy will provide the coverage for both vehicles, that is owned vehicles as well as hired vehicles. So this is an important feature of the policy, that the carrier's legal liability policy covers legal liability of the road carriers for actual physical loss or damage to the goods or merchandise or cargo, while such goods or merchandise are carried by them under the contract of carriage. But mind one thing, the carrier legal liability policy will pay only for the physical loss or damage of the goods or cargo, not of the vehicle. The liability of loss or damage to the vehicle is not covered under the carrier's legal liability insurance policy. This policy relates only to the loss or damage to the cargo, to the goods. So the basic coverage of the policy is, this covers the liability of loss or damage to the goods by fire, by explosion or accidents. These are the three common terms: fire, explosion and accidents. Arising due to the negligence of the insured or negligence of the insured's employees or his representatives or his servants or loaders and unloaders. So not only the fire, explosion or accident, negligence is also covered. Negligence or criminal act of the insured's employees. So if the vehicle is damaged by such fire or explosion or accident and a claim is admitted under the motor comprehensive insurance policy covering the vehicle, not under this carrier's legal liability insurance policy. So in addition to the fire, explosion and accident and negligence, two more covers are available for the carrier's legal liability policy on payment of additional premium, and these are the add-ons which are known as the writing strike and terrorism. So the insured want the coverage wider, he can pay for both the add-on covers and take writing strike and terrorism. Optional covers, warranty covers, not compulsory, available only on the payment of additional premium. Now, other key considerations of the policy are, this policy is available only for the 12 months. Maximum period is 12 months. Then the policy can be renewed for the next year. Policy can be renewed for further years. Carrier should be a reputed transport firm. And is all the vehicles which he is using for the transportation, may be owned or hired, must be comprehensively insured under a package policy, motor package policy. This is our precondition, that all the vehicles which the transporter firm is using for transportation must be insured under a package policy. And a motor package policy covers the risk of third party as well as own damage as well as personal accidents. And this cover must be maintained throughout the period of carrier legal liability policy. If at all any motor package policy of any vehicle which is used by the transporter is expiring in between, in that case he can renew it in continuation, so the policy will be continued. But if at all on any day of the loss or damage to the goods, if the vehicle which was carrying the goods found uninsured on that day, or the package policy expired the day before, or it was having only third party policy. In that case, the carrier's legal liability policy will not pay the claim. Because the motor package policy should continue and should be valid on the date of loss. Subject vehicles must be in the roadworthy condition. If the GCCB of any kind which is used for the goods carrying, its fitness is the proof of roadworthy condition. Because the roadworthy condition can be determined of a GCCB only by the fitness certificate, and this fitness certificate is issued by the RTO office. No other document is valid for the roadworthy condition. Fitness of the vehicle will be examined from the fitness certificate only. This policy provides a fleet policy. This fleet policy can be issued to insure all the vehicles, to cover all the vehicles which the transporter firm is using for carrying the goods. So under one single policy, all the vehicles owned or hired can be covered throughout the policy period. That is 1 year. Maintenance of proper record or logbook for each vehicle is required because these are the documents maintained by the transporter firm throughout the period. These are the documents related to the transport business or carrier business or the logistic firm's business, because the books will tell about the presence or transportation or the place where the GCCB has gone to deliver the goods. So this kind of entries are made in the logbook that will be a sufficient proof to examine about the vehicle on that particular date. Another document is consignment note, which is also used by the transporter firms for proper recording of the vehicles, what consignment was sent in which vehicle. This detail you can find out from the consignment note, which will go to the transporter firm. And the minimum premium of the policy is 500 plus GST, and GST is available today or applied today at the rate of 18%. So these are the certain key considerations of this policy, that the policy will not be issued for more than 12 months, but it can be renewed after every year. It is given to the reputed firm. Their precondition is that all vehicles used by the transporter firm must be insured under a package insurance policy. All the vehicles must have the fitness certificate of the roadworthy condition. One fleet policy will cover all the vehicles used by the transporter firm. Transporter firm must also maintain the logbook and the consignment note for the recording of the vehicle and the detail of goods. Now, one important factor of this policy is that the cover duration is required by the transporter firms. What cover duration will be covered under the policy? Cover duration means from what date the policy will cover the risk and when the risk will be ended. So here the concept is that the duration of one consignment of one vehicle and one transit is the commencement of cover will start from place of origin with loading of cargo or goods or merchandise on the vehicle. Point of origin means where from the vehicle will go. That would all. And until the same is unloaded at point of discharge or expiry of 3 days from arrival of the vehicle at the final destination. So final destination means point of discharge, means to which place it is going. If it is going to Hyderabad, Bangalore, Chennai, Kolkata, Mumbai, so that point will be called as the point of discharge. That is the final destination. To that place, the vehicle will carry the goods. Now, from the point of origin to point of discharge, or from the point of origin to final destination, risk starts right from the loading operations. Even the vehicle has not yet started, but the risk has started because the loading operations are continuing. And even when the loading operations of the goods in the vehicle, there is the possibility of loss of damage. If anything is slipped from the ends or it is mishandled or it is negligently loaded, the goods can get damaged. So policy starts with loading at the point of origin and continues till the entire journey and until the vehicle is reaches at the final destination, that is the point of discharge. Still the risk continues. If the vehicle is unloaded, goods is safely delivered, the risk is over. But if it is not unloaded, due to any reason, maybe there is no place in the godown of the transporter firm, so vehicle is parked as loaded cargo. In that case also, the risk is covered under the policy for first day, second day and third day. So either the vehicle is unloaded or expiry of 3 days, whichever is earlier, the risk will continue. So we are granting 3 days comfort zone for every transporter carrier firm, because in these 3 days, whatever loss is taking place, even in the parked vehicle, the insurance company will pay the loss of damages. Because there are chances where the goods can get damaged even in the parked vehicle. Because when the mixed cargo is there, the nature of the goods differs. The weight, the smell, the chemicals, the inherent properties, the size, anything could be the cause of loss. So the cover duration is very clear, and this is providing 3 days extra right from the point of origin, wherefore the policy starts with loading and till the risk continues till the vehicle reaches to the point of discharge, that is the final destination. And if it is unloaded, the risk is over. If it is not unloaded, then the risk will continue for next 3 days, whichever is earlier. Now, how the policy will be rated? For rating, 3 things are required, that is gross vehicle weight, limit of indemnity and other covers. All these 3 things will decide the premium rating, because the gross vehicle weight is available in the registration certificate of each vehicle that is issued by the RTO. Limit of indemnity will be decided by the proposer firm, transporter firm, because they know what is their annual turnover, what was the annual turnover in the previous year, what could be the annual turnover of this year. So they can take the expected turnover and they can decide the limit of indemnity to be selected under the policy. Then there are 2 add-ons. This is the choice of the transporter firm to select both of them, one of them and none of them. The company also provides the discounting and loading on the basis of the type of vehicle body. Maybe the vehicle is closed body, trailer, refrigerator, tanker, on the size of the fleet and past claim history, and other period parameters like age, fitness of the vehicle, type of cargo, etc. On each claim there would be 2% of the compulsory excess. 2% or subject to minimum of 5,000 for region and less, and terrain with weight differ. So that's the way the policy will be rated and premium will be applicable to the policy. Now, policy will not cover certain risks. These are included in the general exclusions. So, for example, third party risk is there. A fully loaded truck of a reputed transporter firm, which is covered under the carrier legal liability insurance policy, is going, and that fully loaded truck hit the person which was walking ahead of the truck. So the third party got injured or run at the spot, and after some time died. So this is a third party loss. This is covered under the Indian Motor Vehicle Act 1988. This is not covered under the carrier's legal liability insurance policy because this risk is insurable under the motor package policy. Motor policy will pay the loss. Even motor third party risk is covered. But our condition is to have the motor package policy for each vehicle. So the motor package policy will be covering this risk, and this carrier's legal liability policy will not pay any claim for third party injury, death or disability or property damage. Liability arising out of any contract is also not covered. Goods belonging to the servant, agent or subcontractor of the insured firm is also not covered. Loitering strike is excluded, but on payment of additional premium it can be covered. Act of terrorism is excluded, but on payment of additional premium it can be covered. Inherent defect or vice is also not covered because the items or the goods or the cargo which is of the nature where the inherent defect or bias can damage the stock without any accident, without any explosion, without any fire, then this loss will not be paid by the policy. Because sometimes damp, wear and tear, deterioration, spontaneous combustion can cause the loss because these are certain perishable items where the decay is possible, like fruits, vegetables, milk products, bakery items. So those products which are having very short life and they are subject to decay, they are known as the perishable goods. Then the consequential loss. Loss is caused by depreciation, delay or loss of market value. Change in law, refusal for grant of any necessary permit or license by government of authority or contraband vehicles. So document, if it is not issued by the RTO, the insurance company will not pay the claim under the legal liability also. Say for example, the transporter firm is not having the proper permit to go to the other states and the permit granted is only state permits. So they cannot send the goods to other states through this vehicle because this does not have the national permit. It cannot cross the boundaries of the states. Secondly, contraband items are not allowed. Contraband is illegal items or which are not permitted by the law. For example, liquor, drugs, or any intoxicated item. So they are not necessarily carried by the transporters or carriers. These are contrabands, they are not legally allowed to carry. So if it is carried, the policy will not pay any claim for loss or damage to the goods. Excess or deductible is always there in the policy. Now if at all there is any loss or damage to the goods, immediate intimation is required to be given to the insurance company because the insurance company will check the policy and when found valid, they will appoint a surveyor who will immediately rush to the spot to physically check the loss or damage. When he will physically check the loss or damage to the goods carried by the transporter firm, the certain documents will also be checked, and after that verification only the loss will be assessed by the surveyor and that assessed loss will be settled. So this is not possible to pay the claim of any goods or cargo unless it is physically verified. There is a possibility of partial loss or total loss or even the fire loss. So unless it is physically verified, the claim will not be settled. And when they settling the claim, there are certain different kind of documents which are required for settlement, like motor package policy. First of all, it has to be checked. Then, Registration certificate of each vehicle which is carrying the goods and used for the transportation purposes. Agreement letter if any goods is carried through under any agreement. This is applicable where the exclusive items are carried. Say for example some cement factory is sending the cements exclusively. Textile mill is sending the clothes exclusively. Footwear factory is sending the footwears exclusively. There is no mixed cargo. So that kind of agreement is there. A copy of that agreement will be checked. Certificate of registration under the Carriage by Road Act 2007. This is a certificate of registration which you will find displayed in the office of the transporter firm. This is the registration certificate issued by the Carriage by Road Act 2007 by the respective transportation department. But this document is not issued by the RTO. RTO is issuing registration certificate of the vehicle. The certificate of registration is issued by the transport department under the legal provisions of the Carriage by Road Act 2007. Then fitness certificate is required for GCC. Every GCCB is subject to fitness. And proposal form and claim form, goods received as may require, goods forward note as per requirements. So these goods received and goods forwarded is per the detail provided by the transporter, because transporter when receiving any goods for transportation purposes, they are issuing a goods received to the owner of the goods, wherein they are providing brief detail of the goods and they are keeping in their custody and have charged freight for that. So the goods received is one document which the owner of the goods must be having even when the goods is not in his possession and it is given or handed over to the transporter firm. Similarly, the goods forward note is a document which is prepared by the transporter firm and sent to the another transporter where the goods will be unloaded. So these are the documents required at the time of claim to settle the claim of the carriage legal liability insurance for the loss of or damage to the cargo of any person. Because even the transporter is not aware whose goods it is unless it is checked from the documents called GR. Now, if you want to sell this policy to any of the transporters or the carrier or the logistic firm, the basic bare minimum information you are required to collect on the proposal form is this one. Number of vehicles to be covered, gross vehicle weight as per the registration certificate of each vehicle, limit of indemnity for each vehicle, that is anyone accident limit. Is add-on required, that is 2 out of the 2 add-ons have written stack and term if any add-on is required. What is the type of vehicle body being used by the transporter firm, that is float body, tanker, refrigerated vehicle, trailer. Then age of the vehicle. Age of the vehicle will be checked and found out from the registration certificate, because the registration certificate does have every detail of the vehicle. Then type of cargo is cargo. Cargo could be the exclusive or the mixed items. Past claim history relates to the transporter's insurance history, where on the previous policy how many claims the transporter firm has taken. The past claim history will entitle the coverage for the transporter firm, because that could be a reputed firm. And is a single policy required or fleet policy required? That information is required on the proposal form to get the quotes. Only thereafter the policy will be issued. If the fleet policy is required, whatever number of vehicles owned by the transporter, whatever number of vehicles hired by the transporter, all of them will be covered under the policy, because they are the vehicles used for the transportation purposes. Then throughout the policy period of the carrier's legal liability insurance, motor insurance policy should continue. Package comprehensive policy should continue irrespective of each vehicle which is covered under the carrier's legal liability policy. So the carrier insured need to renew the comprehensive motor insurance policy if the policy expires, otherwise no claim will be payable under the carrier's legal liability policy of the motor package policy. Is not in effect at the time of claims under carrier legal liability policy, the insurance company will not pay any claim. So carrier's legal liability policy can be given to all type of cargo carriers, irrespective of goods carried subject to growth or subject to goods can be covered as per underwriting guidelines. So these guidelines are already sent to all the offices. Now, the common carrier or the carriers are transporters who are registered under Carriage by Road Act 2007 and they need this policy. They are the reputed firms and they are having the number of vehicles for carrying the goods, and it all depends upon their turnover. According to the turnover, they will select the number of vehicles to be covered under the policy and they will take the carrier's legal liability policy on the fleet basis. So the carrier's legal liability policy is given to road transport companies working as common carriers of cargo or goods. But why the transporters are not taking the marine transit policy? Because the journey of the vehicle or journey of the loaded vehicle, they are not taking the marine transit policy, they are taking carrier's legal liability policy because this is the policy which will cover the risk of a transporter firm. Marine transit policy or marine policy will cover the risk of the goods, cargo, merchandise, but not the liability of the transporter. While the carrier's legal liability protects carriers against their legal liability or claims arising due to the damage to transported goods or cargo, whereas marine policy indemnifies the consignor or consignee for the loss or damage to goods, cargo during the transportation. So the basic difference is marine policy can be taken by the owner of the goods, buyer, seller, consignor, consignee, because they are the concerned people who can directly take the claim from the insurance company. But carrier's legal liability taken by the transporter because this is liability policy. If he is taking the marine transit policy, he cannot take the claim because he is not the owner of the goods. He is only the custodian of the goods. Custodian for the short term. So insurance company will not pay the claim to the transporter firm for the loss or damage to the cargo. Insurance company will pay to the owner only or the person who has the insurable interest in the goods. The carrier firm has no insurable interest. They are only concerned to protect and safely deliver the goods at the final destination to the owner of the goods or to the person directed by the owner. So there is a basic difference between the carrier's legal liability policy and the marine transit policy. So transporters being the professionals, so they have to cover the professional risk of the transportation business. So throughout the policy period or throughout the 1 year, the transporter firm will not pay any loss or damage to the cargo if he has taken the carrier's legal liability policy because the insurance company will pay. So the vehicles covered can be owned or hired or chartered and can be insured for shorter duration and maximum policy period allowed in one go is 12 months, but not more than 12 months. So the policy can be issued for 12 months only or 1 year only. But yes, of course, vehicle can be insured, either owned or the transport or the hired. Luckily, in both the policies, that is motor vehicle policy and the carriers legal liability policy, the under insurance is not applicable. Because all the motor policies are issued on the basis of the IDB. IDB stands for the insured declared value, that is determined through a table. Table is provided in the tariff, and for first 5 years there is a percentage decided to be deducted from the amount of the purchase. So every year that percentage will be deducted, and that will keep on increasing every year till 5 years. The table will confirm, but thereafter also 10% value will be reduced every year. That is called the IDB. So this IDB concept is not applicable to this carrier legal liability insurance policy, because this is a non-motor policy. Moreover, no value is known to the transporter firm of that goods. So the under insurance is not applicable to the motor insurance as well as to the carrier legal liability insurance. In carrier legal liability insurance also, under insurance is not applicable because the transporter is only the custodian and not the owner of the goods. You don't know the value of the goods, at what price it was purchased. You don't have that bill. He is only aware about the value mentioned by the owner of the goods in the GR. So under insurance is neither applicable to the motor package policy nor the carrier legal liability policy. But the liability will be paid under the carrier legal liability policy in full up to the any one accident limit or any 1 year limit, subject to policy deductibles or policy compulsory excess. Now, the sum insured of the policy will be determined on 2 factors, any one accident limit or any 1 year limit. And this sum insured will be selected by the proposer firm, that is transporter or carrier. Whatever sum insured they are selecting for themselves, that will be covered throughout the policy period. Now the question is, the transporter firm has to calculate this. Now on what basis they will calculate? That basis is important to understand, because 2 limits have to be decided. And these 2 limits are known as the any one accident limit and any 1 year limit. So this is a simple case of the tanker to understand how the any one accident limit will be examined or worked out. Because in one vehicle, at one journey, for one journey, what is the possibility of maximum loss? That is the any one accident limit. Maybe suppose if this is not a tanker, no fuel is there. If it is empty, the maximum liability of the insurance company is related to the vehicle only. That will be covered under the motor policy. If it is full, duly filled, then the carrier legal liability will cover the risk, because the carrier legal liability is covering the risk of goods and damage, goods of cargo only. So there is a loss to the vehicle that is not part of the carrier legal liability policy. Now only the liability of goods is there, so goods have to be seen how much goods can be filled in one vehicle. So what is its maximum carrying capacity? What is the GVW? That can be checked from the registration certificate. So one time, goods cannot be more than its registered capacity. If at all the transporter firm is carrying goods more than its registered capacity, in that case, they are responsible for the losses. Insurance company may deny the liability on account of overloading. So here the example says how to determine the AOA and AOY. So any one accident limit will be decided on the basis of the maximum carrying capacity of that vehicle that will be multiplied with the rate of the vehicle. Say suppose the petrol is carried in a tanker and the rate of petrol is 100 rupees and the maximum carrying capacity is 5,000 rupees. So the example says the animal accident limit is only 5 lakh rupees. Any one accident. There could be 10, 20, 50 accidents in a year. But for each accident, if the liability is selected as 5 lakh rupees, insurance company will not pay more than 5 lakh rupees. It can pay lesser amount because the lesser amount is actual losses. If the losses of rupees 1,50,000 only, company will pay 1,50,000. But if the loss is of 7 lakh rupees, insurance company will pay 5 lakh rupees only because the AOA selected is only 5 lakh rupees. That is animal accident limit is maximum 5 lakh rupees. So if it is the maximum carrying capacity is 8 lakh rupees, the liability of insurance company could be 8 lakh rupees. So that is the way how the sum insured is selected on the basis of the any one accident limit. Now, for any 1 year. So what is the total turnover in 1 year? That will be covered under the policy, under the AOA category. Or if it is not easy to determine or to work out that 1 year's liability, in that case, the total number of vehicles, maximum carrying capacity is multiplied with the 365 days. So any 1 year sum insured is built up. That will be covered under the policy. Now once the AOA and AOY limits are decided, on that limit the premium rate will apply. And it could be according to the items or the cargo or the material carried by the transporter or carrier firms. If it is highly hazardous and flammable, rate may be high. If it is non-hazardous, rate will be 10%, 15%, 20%. It depends upon the cargo carried. And now, this liability is a legal liability, but the policy is not mandatory like motor vehicle policy. Policy as per law is compulsory, that is motor vehicle insurance policy, and there again the third party policy only. But our requirement in this policy is that this motor package policy should be there for each vehicle which is used by the transporter firm for carrying the goods. And this policy should continue throughout the policy period, because at the time of date of loss, if it is found that the vehicle was not insured under motor package policy, the carrier's legal liability policy may deny the claim. So for the simple reason, when you are selling this policy to any of the transporter firms, you can directly tell them that all our vehicles should be insured under the motor package policy. If we are having only 25 vehicles and 10 vehicles we have hired, it is your duty that all the 35 vehicles should be insured under the package policy of motor insurance. Though you have no insurance interest in the other hired 10 vehicles, but tell the owners of those vehicles to submit the policy copy to you. And that is package policy, you must check it. Otherwise, the normal pulse also, the transporters firms are not using the third party policy for their vehicles. Reason being, a commercial vehicle normally costs 30 lakh, 35 lakh, 40 lakh, and more than that to the crores. So for such a heavy cost of the vehicle, who will take the risk for own damage risk? And own damage risk means total loss is also possible. Theft of the vehicle is also possible. So that liability will be the part of the motor vehicle act only. And that will be covered under the motor package policy. But as far as the liability relating to the goods or the cargo or the commodities is concerned, the entire liability will be covered under the carrier's legal liability policy, and that will be issued for 1 year only. And the coverage is restricted to fire explosion, accidents and the negligence. Good thing is, cover duration will provide 3 days extra, because even in the parked vehicle until it is unloaded, the risk of loss or damage is always there. Suppose the entire cargo is burnt in the vehicle itself, or suppose the vehicle is overturned, or suppose the parked vehicle is hit by any other vehicle. So the possibility of loss or damage is still there. That risk is covered for first day, for second day, for third day. Thereafter this will discontinue. Because number of vehicles are used by the transporters, all vehicles, this problem may be faced. So this is a routine problem, routine problem faced by all the transporters of carriers because of the dependency on the other transporter, where the final destination is there, the point of discharge is there. There, if the godown is not empty or the place is not available to unload the vehicle, how the vehicle will be unloaded? So this is a comfort given in our policy that for next 3 years, 3 days, from the final destination or the point of discharge, when the vehicle reaches there, the policy doesn't end with reaching only. Policy will end under the two circumstances: either the goods is unloaded or expiry of 3 days, whichever is earlier. So this is all about the carrier's legal liability insurance. If you want to ask anything, you can ask. If there is any question, you can ask. Those who have not sent the yesterday's test paper, they can submit it today. And today also I am sending the test paper on your mail ID. It will reach within 5-10 minutes. You can attempt it, you can click on the submit button and this will continue automatically. This will take another 2-3 minutes if it is working well.